Tonight, 10 takes on the Sacramento County Sheriff's Department and questions about high-tech surveillance equipment.
Well, they assured us the device known as StingRay is not being used here. But News 10 investigative reporter Tom Jensen has new evidence suggesting otherwise.
When you dial up or text a friend, or surf the internet using a mobile connection, that cell tower you think you are connecting to might not really be a cell tower. It could be a police or sheriff department StingRay.
It's essentially a fake cell phone tower.
Hani Fakori has been fighting to protect Californians from invasive surveillance techniques for more than a decade.
We've been assured and promised that they're not being used in that way, but we don't really know for sure.
The StingRay is mobile, and it can capture all data from anyone who connects to it. In doing so, critics say the StingRay creates a problem of illegal searches and Fourth Amendment violations.
The California courts have not weighed in on the proper framework for how the police should be using these devices. News
10 filed public records requests with all local police and sheriff's departments in California asking whether they use the fake cell tower devices. And we found Oakland has one, so does LA, San Francisco, and San Jose. A total of 6 communities admit they have them. But the Sacramento County Sheriff's Department told us it does not own or use StingRays and has no records responsive to our request.
The Sacramento Sheriff has an obligation to respond under the Public Records Act. If they're withholding something from you, they should tell you that they're withholding and what the basis for it is.
Certainly they shouldn't be lying about it, saying that they don't have it when they do.
Peter Scheer is with the First Amendment Coalition and promotes open government and access to public records. Scheer is concerned about our records request in Sacramento because we showed him documents from other law enforcement agencies who applied for grants to buy StingRays. That's where we found out the Sacramento County Sheriff's Department might in fact be using a StingRay device despite its responses, especially in these records from San Jose Police. San Jose PD said they did extensive research and contacted police agencies in California that utilize this type of technology, and that the Sacramento County Sheriff's Department was one of them. We also obtained this receipt from Sacramento County showing the Sheriff's Department paid more than $11,000 for a piece of equipment sold by the same company that makes StingRays. It acts like a filter and amplifier for StingRay-type devices. And recently, after we were armed with that new information, the Sheriff's Department modified its response, telling us in an email the Sheriff's Legal Counsel is coordinating a response to our questions.
You don't know whether that means, in fact, no responsive records exist, or there are no responsive records that do exist that we're willing to give you.
Or maybe that response will be, well, sorry, we misled you. We do have the technology, but I guess that's another issue. But still, this technology, it could snare totally innocent people. They're just not listening in to the bad guys that they're after. Anybody could be logging onto this.
And that's the Fourth Amendment issue here. It's the illegal search and seizure. That's what the Fourth Amendment says. You can't just cast a wide net over everybody and start pulling in information or going door to door in somebody's apartment building looking for somebody, knocking down the doors of everybody to find one person or to find out if other people are committing crimes.
You know, unlike a new vehicle or some other piece of equipment, law enforcement agencies do not advertise that if they do indeed have this. Is there a perception by some law enforcement agencies that there could be a constitutionality problem with this piece of equipment, so they just try to keep a low profile?
Well, I don't know if they feel that there's a constitutional problem here, but I do know that they're being very secretive, and one of the reasons might be is that the company that makes these, the Harris Corporation, makes them sign a non-disclosure agreement. So they're told that they can't talk about these things. Even when we get these documents, when we're able to, they're heavily redacted. There's hardly any information in there. The problem is you can't have a non-disclosure agreement that just supersedes the California Public Records Act.
Well, and when you go to court with evidence that they obtained with this device against the bad guy, they have to tell how they got that evidence. So it's going to come out sooner or later unless they make an effort to mislead the court on how they got the evidence.
Say they got it from a confidential informant who you don't have to give the name of. You know, it just leaves it open for a lot of abuse because there is no third-party oversight from the beginning.
All right.
Okay. We know you'll continue to follow it. Thank you very much, Tom.
And we'll see the response we get. Yeah, Tom, thanks.